各位，我哋而家夠
Members, this is the appointed time, and we have a quorum. So, welcome to this meeting, which is the Bills Committee on Waterworks Amendment Bill 2017. This is the fourth meeting. First, we need to follow up on the issues arising from the last meeting. The administration has responded to the issues raised by the legal advisor. And at the meeting of the 19th of June, the administration was requested to provide information to issues that members raised, and the response is set out in CB bracket 11254/1617 bracket 02, and I would like to invite the administration to walk us through the paper, please. Mr. Mack. As Chairman mentioned, on the 7th of July, we issued a response paper to clarify the issues raised at the last meeting. I'd like to walk through the response. We now have different categories of licensed plumbers and registered skilled workers, and the annex set out the relevant figures, and in column 4 of the paper, we have 3,303 licensed plumbers and also some 16,000 skilled plumbing workers, and I won't go through the details. The figures are set out in the table. For the different types of workers, we set out the work that they can take up under the ordinance, and again is set out in the annex. And for question A2, there was a question on what workers could take up the supervisory roles and to give instructions. We have not provided the answer in the column as such, but in the written reply we explained that for the plumbing workers and fire services workers, so on and so forth, whether they are skilled or semi-skilled workers, they can provide instruction and supervision. As for item B,
之條例之下呢，有一啲叫做即係 minor nature 嘅工。
in relation to minor works of a minor nature under the ordinance, whether it can be included in the bill, our response is that in relation to the Waterworks ordinance, the Waterworks Authority is empowered to give interpretation, and on our website we have also elaborated on what minor works mean, and by taking this approach we provide flexibility. Such that in relation to the plumbing trade, the Waterworks Authority can make amendments from time to time, whereas if it is included in the bill, it may take a longer time if we make amendments. So we're more inclined to keep the existing arrangement. However, if members think that it should be clearly spelled out in the ordinance, then at the next stage we can consult the trade to see what is the most appropriate arrangement to be put in place. And for this amendment bill, we don't propose to make any change, because if we amend the bill, we need to consult the trade on the definition of minor works and how it should be incorporated into the bill. And that will take some time. So our proposal is not to include this definition in the bill, so that there is flexibility for the Waterworks Authority to explain what minor nature means. We like to keep it flexible, and that's our succinct response. For points C and D, the question was whether a condition can be included in the license so that or the written permission requiring that works be completed in a certain time frame, say within a year. And we have sought legal advice. The Waterworks Ordinance at the moment allows the Waterworks Authority to include such a condition. As such, we don't propose to make any amendment to the bill. And the department will discuss with the trade when giving written permissions in the future how the condition in relation to the works procedures can be incorporated. Any questions, Dr. Helena Wong? Chairman, last time we asked some questions in relation to the supervisor. That is, who can be eligible to take up this work, because this category of persons can apply for exemption, but there is no stipulation in the bill as to who can give instruction and supervision. And according to paper 02, the supervisor includes a licensed plumber or registered plumbing worker, including a skilled or semi-skilled worker, but does not include a provisional worker. So does it mean that, according to the administration, the supervisor could be a licensed plumber, a skilled or semi-skilled worker? So all three categories of workers can be supervisors, Mr. Mack. Basically, it is correct. Now, according to our response set out in the paper, a licensed plumber, a skilled or semi-skilled worker can provide instruction and supervision. And in fact, in the bill, Chairman, is in 13B. (13B) doesn't specify the definition of a supervisor. Where can we find the definition of a supervisor? Is there a definition of a supervisor in the bill? That is, who can be a supervisor, and as such the worker can be exempted from certain liabilities? Well, the legal advisor has pointed out that in 007, page 007 of the marked up copy 6B, it stipulates that the specified plumbing or a person who carries out specified plumbing work under the instruction and supervision of a licensed plumber or a registered plumbing worker. So it says here it's either licensed plumber or registered plumbing workers. So both A and B can be a supervisor, but where in the bill provides the definition of a supervisor? This is just the interference, the inference drawn from what the administration replied. But there is no clear definition. But as the legal advisors pointed out, bracket 6, page 7, a person who carries out specified plumbing works under the instruction and supervision of a licensed plumber or a registered plumbing workers, meaning that the licensed plumber and a registered plumbing worker can provide instruction and supervision. So may I suggest that the administration provides expressly in the interpretation section what a supervisor means, and that is points A and B. But I need to ask another question here. Well, A is clear, a licensed plumber. B, a registered plumbing worker, including a skilled or semi-skilled worker. But there is an issue here. If you call all of them supervisors, the training that these three categories of persons receive, their legal knowledge, the level of skills, time required for training, and the examination required, qualifications, their pays, all are different. If we just call them in general the supervisor, which would lead to criminal liability, which may be incurred on these persons. The problem is they undergo different training and they have different qualifications. So has the administration thought about this? Since they are all called supervisors, they should undergo a certain level of training, or the administration should even consider imposing a licensing mechanism, or rather consider, instead of allowing three categories of persons to be supervisors, the administration would only allow a licensed plumber or a skilled worker to be the supervisors, because they have to undergo a certain level of training and be equipped with a certain level of knowledge about the ordinance. Basically, the person will only be taught about the skills. Perhaps the semi-skilled worker and the skilled worker may only be able to teach what they know, and the training they provide may be different, or the instruction they provide may be different. And in terms of the training courses, a skilled worker is not required to have full knowledge of the Waterworks ordinance, unlike the licensed plumber. So our concept is that the skilled worker is a master of skills, and he will be coaching his so-called apprentices in performing the jobs. So of course, he'll be responsible for his own task, and if he delegates this task to someone else, then he will still be responsible, because he is only delegating his task to someone else. So it is not the case of the same level of responsibility delegated to different types of persons. Let's say when it comes to prosecution and criminal liability, we'll consider the work taken up by the person concerned, the scope of responsibility, let's say a licensed plumber and a semi-skilled worker may be taking up supervisory work, but the scope may be different, because for the semi-skilled worker, his scope of work may be more confined. So the instructions given may be different in scope. So under the designated skills for designated responsibility for designated trade arrangement, in fact, it has come into effect since the 1st of April. We should allow another member to ask questions first.
Mr. Shiu. Mr. Chairman, now you only can prosecute after you have discovered the problem. And it's difficult to get the workers into the trade. Why don't they work on electricity? Why they should work on plumbing? If you are good at studying, you don't need to choose to be a worker. And if you put the criminal liability on them, we are not very optimistic about getting enough workers. As for the electricity ordinance and also lifts and escalators ordinance, you claim that you adopt the same approach. I just want to ask our legal advisor, would you look into the lift and escalators ordinance and also electricity ordinance, whether the provisions and ideas are the same in comparison with the present bill? Yes, Mr. Mack, and then our legal advisor can search for the information. At present, now before the bill, the law is amended, anyone, including any worker who has made use of substandard materials, then the person has committed an offense. Is there any criminal consequence? Yes, there is. Sorry. If there is already a criminal consequence, then you can arrest those in the lead in water incident. Mr. Mack, please go on. As the law says, the prosecution has to be taken out within 6 months of the offense. Our change or amendment to the law is prosecution within 6 months of the discovery of the offense. As for the lead in water incident, the incident was discovered more than 6 months after the offense, and therefore we cannot do any prosecution. The ordinance imposes strict liability on the person. If he has used a substandard material, then he is in breach of the law. There is no defense. But now we have given a statutory defense to the defendant. We want to find a balance. On one hand, we want to preserve the criminal liability in the ordinance as a deterrent. This is to prevent somebody who deliberately makes use of substandard materials. We stress that this is a deterrent. This is to prevent a deliberate act. And at the same time, we add this statutory defense. If he's just doing his own job, somebody instructs him to do something, say a person acts under the supervision of another skilled worker, and he does his job, then he has fulfilled the requirement of the statutory defense, and therefore there will be no prosecution. If we start a prosecution, we have to collect evidence. We have to obtain adequate evidence before we can proceed with prosecution. the workers nor the licensed plumbers are required to keep records for their whole life. They are not allowed. They are not required to keep any record to prove that they're innocent. Now, let me give you some example for the ease of understanding. Say, let's take the lead in water incident as an example. Now, according to the law, can you explain to me why you can't prosecute them? The law, as it stands, requires the prosecution to be taken out within 6 months of the offense. The lead in water incident was discovered more than 6 months of the offense, and therefore we cannot, or we could not prosecute, because the time limit has already been exceeded. Therefore, we amend the law such that prosecution will has to be taken out within 6 months of the discovery of the offense. So it can be for lifelong. Now, as for the lift and escalators ordinance, the relevant provision is Section 142. If prosecution is taken out, it is to be taken out 6 months counting from the next day of the discovery of the offense. So there is a time limit. There is also a time limit for prosecution under the company's ordinance. Members can make a policy decision as to what is the appropriate time limit. You can decide whether it's 6 months or other time period. Say, for example, company's ordinance, there is a time limit. It's rather special. Section 98 of the ordinance is for it is 12 months after the act is known to the SVJ, or the discovery, or 3 years after the discovery, or within the discovery of the offense. Yes, the legal advisor has already explained that it's similar to the lifts and escalators ordinance. Do we have a time cap on for each member? I think it's meaningless to set any time limit for each member, because the questions are common, and I don't want a member to take up too much time. Well, I have not finished with my questions. Maybe you wait in the line. Mr. Poon Siu-ping. Just now, the Bureau has explained to us who are supervisors, who are general workers. According to your table, there are about 26,000 workers who can be supervisors, covering the plumbers and also fire services workers. About 210,000 are general workers and provisional workers. These general workers are not qualified to deal with plumbing works because they are not registered. So if they deal with this, then they have breached the law. Last week I met those in the trade. Now, they said that it would be difficult to prosecute. Now, with the amendment of the law, there is the sword hanging over the head of these general workers. I just want to understand this further. Now, of these 210,000 odd general workers, they are working under the supervisors. If there is a problem with their works, then in the future these workers will be given a defense because they are working under instruction or supervision. I don't know whether my understanding is correct. From their point of view, they say they think that there is a sword hanging over their head. You can prosecute them at any time. I just want to clarify this point. If these general workers do not follow instruction, they just do whatever they like, they therefore cannot meet the requirement of the law. Is it the case? Now, let me answer Mr. Poon's question in two ways. First, our proposed amendment is to give a defense to the worker if the worker follows the instruction and supervision. He is absolved of any criminal liability. We want to catch those who deliberately breach the rule. As for the present ordinance, as it stands, anyone, including any worker, who has used the wrong kind of material is in breach of the law. The WSD doesn't want to prosecute people, but it doesn't mean that we cannot prosecute under the law. They are two different things. The policy intent doesn't want things like what they are, as described in the ordinance. We want to find a balance by moving this amendment bill. The balance is this. If we absolve all the workers, then it will be more lenient than the present ordinance. But we have to consider the interests of the public, because that will affect the quality of potable water consumed by the public. So we need a deterrent to deter workers from deliberate act of breaching the rules, and in this way we can ensure good water quality for our citizens.
我話即係留返嗰個。
Now we have kept the offense, and we provide a defense on the other hand. Even if they have committed the offense, they are not subject to any imprisonment. We have not asked for imprisonment. It's still a level 4 penalty, up to $25,000. So the penalty is the same after the amendment. Now, if the worker follows the instructions completely, then that's the ideal situation. But he follows the instruction. He followed the instruction, but the supervisor denies that the worker had followed the instructions fully. Well, collection of evidence is the onus of the department. We have to have evidence beyond reasonable doubt. Generally speaking, if a worker or their worker is able to provide information as to how he has followed the instruction or supervision, then it will be not easy for us to have a successful prosecution.
唔該，主席。其實聽咁多同事嗰個意。
Dr. Edward Yu. Well, I can see that members' views are consistent, and that is this is a leap too far. I mean, as far as the objective is concerned, because of inadequate or insufficient number of licensed plumbers in the market at the moment, you need to delegate responsibilities to registered plumbing workers as well. And that is why you have the amendment bill. But the point is all these categories of persons will be criminally liable, and that causes alarm. And in fact, you have the site safety supervision plan in the construction laws, and I think this is called a site safety supervisor plan, and that has arisen because of a collapse of building incident. So if you do not have sufficient licensed plumbers, you can have another tier, that is registered plumbing supervisor, and you can impose a licensing requirement and a registration requirement, and you can also mandate a continuous professional development. You can have a similar framework for the top tier, the AP, the authorized person. The requirement is the highest, and then you can also have a licensed plumber and then TCP who will be required to undergo certain training courses. If you set up such a framework, you'll be able to meet your objective. Would you consider it? Thank you, Dr. Yu, for your suggestion. Well, as I mentioned in the first meeting, the amendment bill seeks to reflect the current situation in the trade in the law, and will soon proceed with the next stage of amendment, targeting contractors, developers, material suppliers, and the matters relating to supervision. We'll consider how we can impose regulations on these personnel, and as I mentioned before, in the beginning of next year we will roll out a proposal. I understand that views in the trade are divergent, and therefore we need to have a rather thorough consultation. And Dr. Yu, may I also respond to another point? The amendment bill doesn't just seek to regulate the trade because of insufficient plumbing licensed plumbers. Rather, we'd like to incorporate the current modus operandi of the trade into the law, because at the moment the task is not just taken up by licensed plumbers, but rather licensed plumbers, semi-skilled workers. These plumbing workers are all taking up the task. But as Mr. Poon just now said, the difference is we are not prosecuting the plumbing workers at the moment, but it doesn't mean that they have not contravened the law. And that means we want to regularize it first, so as to allay the concern of workers who, by taking up the work, may already be breaching the law. Whereas at the next stage, there'll be a lot of other measures rolled out, and by then we'll consult members again. Next, Ms. Alice Mack. Chairman. Well, we understand that this bill is necessary, but we are also concerned about the workers' concerns. You cannot allay their concerns. As mentioned just now, you had meetings with labor unions and trade representatives, but they are still concerned that there is a sword hanging over the head. And in the trade, there is already manpower shortage, and what you do will only deter newcomers from joining the trade and ultimately you affect the quality of work. You explained how workers' responsibilities may be affected and that criminal prosecution will be taken out on certain people only, but still workers are concerned. After introducing this bill, workers may still be affected. Can you further explain so as to allay workers' concerns or revise the wording? Because you mentioned that they'll be given a defense. Well, in fact, last time we met with the trade, including the workers, and we already mentioned that if need be, we will move an amendment. But at least on the administration's part, you can also do something to allay workers' concerns. Thank you, Ms. Mack, for your comment. Basically, we're going to draw up a set of guidelines with the plumbing practitioners and the trade, and we have already set out the skeleton of the guidelines. But then we'll continue to discuss with the trade and the workers so as to reassure them. As explained just now, our objective is not to target workers. We just want to impose deterrence to prevent blatant breach of the law. And how do we do that? As we provided in the written response last time, we will be drawing up a set of guidelines. And our next step is to discuss with the stakeholders, including trade unions, licensed plumbers, and trade representatives, to see how we can improve the wording of the guidelines so that they will not be inadvertently caught by the law. If my memory serves me right, we had our first meeting on the 6th of July, and we discussed with the trade unions on how to implement this. Second point, through various channels, we have heard the concerns of the trade on the bill. Perhaps it has to do with our work in explaining the bill to them. So our next step is to hold briefing sessions so that we can explain the bill better to them. Ms. Mack, tomorrow will be the last council meeting of this legislative year, and definitely this bill will continue. The Bills Committee will continue its discussion in the next term. During the summer recess, can you step up liaison with the trade unions and the workers? I think that with better communication, workers can express their concerns, and if necessary, you can revise the wording so as to reassure the trade. We hope that several months later, in the next legislative year, when we come back, we can expeditiously scrutinize the bill. And meanwhile, you can also liaise with the trade. Yes, we can. I also have some questions. First, the trade and also the chambers of commerce express the same concern about criminal liability, because at the moment it seems rather vague. Well, does it mean that if it's 2 inches short and it isn't discovered until years later, the licensed plumber will still be criminally liable? So for non-compliance surrounding the waterworks installation causing public concern. I think this is the crux of the matter. Only if public interests are involved, because otherwise, if it is too vague, then and if the offence isn't discovered until many years later, there will be an issue about the liability. Second point, I think it's understandable that workers are concerned. Although you explained that there is a defense provision, it means that at the outset they would be facing an allegation. And why is it that they need to be worried about a possible lawsuit? And there is no end to this worry, because it may be many years later until somebody discovers a flaw in the system, in the water supply system. So can you say that if a worker deliberately contravenes an instruction given by a supervisor in the process, the worker will be criminally liable? Can you expressly provide that in the law, such that as long as the worker does not deliberately breach the law, he won't be facing any criminal charge, so as to invoke the defense provision for him to defend himself? This is the concern shared by the trade unions and the chambers of commerce. I wonder if you can amend the bill based on the suggestions I gave. Thank you, Dr. Low, for your comments. In the coming months, we'll be liaising with the trade. We hope that through liaising with them, we can deal with the issue, especially on the drawing up of the guidelines. And as for the bill itself, if need be, we will not rule out the possibility of making an amendment to improve the wording. We will continue to liaise with the trade to make them feel reassured and to allay their concerns. So responding to your question, in the coming months we'll continue to communicate with the trade, and if necessary, we'll come back and propose an amendment to the provisions. Next, Mr. Leung Kwok Hong. Chairman, we have over 210,000 registered general workers taking up this work to make ends meet, and they may inadvertently be caught by the law without knowledge. And Mr. Mack just now explained that there must be evidence beyond reasonable doubt to initiate prosecution, but this is wrong. It's for the judge to decide beyond reasonable doubt whether the defendant should be convicted. So what you said was misleading. If there is ambiguity in the law, then it will be easy to initiate prosecution against anyone. I want to point out that what you said is wrong, because only in the court and a judge can decide whether the charge is proved beyond reasonable doubt. Otherwise, I wouldn't be prosecuted with misconduct in public office. The concern is that you have committed an act, you believe that it's not a wrongful act, and everyone is using the system, and that's exactly what's happening. So as far as legislation is concerned, you need to provide the defense provision. About the offense that I face, the element is that I've committed it willfully. And the second point is that the person doesn't know that he is breaching the law. For the 210,000 general workers, they don't understand that they have this defense, because according to the table, For the other than the registered general workers, 210,000 of them, everyone else will have to be registered, and they're required to have more knowledge than the general workers.
You have to give more protection to the general workers. Though you say it's only a fine, it will not be an imprisonment. Well, if one doesn't do anything and once there was an offense exposed, one is sent into prison. That's really unreasonable. Now, in modern-day society, these group of people are the truly disadvantaged. They have no say. They have no representatives sitting here. They are representatives for business people. They are representatives for those who have to register. So the general workers are 100% disadvantaged, and you should not treat them lightly. We have to speak for the 210,000 workers who are working for the people of Hong Kong day and night. There should be adequate protection under the law. That's the starting point of the legislation. Many members have become very anxious about water quality because of the incident. The spirit of the law should give greater protection to the disadvantaged. I once was a plumber. I was asked to work on a work site, and I was asked to go up the floors and did some plumbing work. Say a plumber, registered skilled worker, provisional plumber, a registered skilled worker. These people are the backbone of the trade, and you have to protect them. You should have stricter supervision on licensed plumbers, because he overlooks everything. Well, it's summertime. You need to consult the stakeholders. The most difficult job is to find out these 210,000 general workers. They are like a pack. Ms. Mack, Mr. Poon should do something. But they really don't know how to find these general workers, but because few join the trade unions. I am against the bill because I cannot allow this piece of legislation to become a plague on the 210,000 workers. These workers are just working from hand to mouth. You really can't hold them legally liable. I don't know how you can find these workers. You may have to work through the trade unions or to work through the labor sector or the contractors or subcontractors. You need to get some people who are representative of the group. You cannot just get a few who just put up a show, and you need to conduct a survey. Well, you may say that I am doing filibustering, but I'm not. You need to conduct a scientific survey to understand or to gauge how much they understand the present law. We can't do much as legislators. The only thing we can do, or at most we can do, is to have a public hearing. And if you get the law passed, and if there is any problem with the workers being inadvertently caught, and then it will backfire on the legislators. As far as I know, the workers are very concerned. This is a very big trade, and you really need the workers. Yes, members have spoken and have expressed similar views, and Mr. Mack has also given an undertaking that he will consult the stakeholders of the trade. Chairman, let me stress that there should be scientific sampling of the 210,000 workers. Dr. K.K. Kwok, I'm not going to repeat the points made by members. I think Mr. Mack has already heard those points. Now you will work on the contractors and main contractors. If you look at the lead water incident, what benefits do individual plumbers get? Did individual plumbers get? Well, they just signed the papers and they took the responsibility, but they didn't get the most of the benefit. Those who get the most of the benefits were those on the top of the chains, just like Shuion or China Construction, and I just name a few. And there is a whole list of them. They make millions of dollars, if not more, out of the use of those of the materials. You shouldn't go after those at the bottom of the chain. You just ignore those on top of the chain who get the most of the benefits. But now your proposal is to penalize those who are at the end of the chain who just make a few $100s a day. I don't understand why you don't have any proposal in respect of the main contractors and the big contractors. But you just asked us to pass this amendment bill first. I don't understand why you have such an approach. Now, in fact, you have let us down on other occasions. Well, you just say that if you are not able to deal with the small fries, then you will go after the tigers. The benefits do not go to the ordinary manual workers. Just the main contractors make millions of dollars. So, Mr. Mack, answer me. Answer me from with regard to specifying the responsibilities of all parties concerned, including the main contractors, the contractors and subcontractors, subcontractors, and then the workers, all the way down. And if you can do that, there will be less concern among the workers. The workers are not to shoulder all the responsibilities or the major responsibilities. Can you do it at one go, specifying the responsibilities of all parties concerned? Mr. Mack, we really want to do that bit as early as possible. As I've explained when I answer Dr. Yu's question, according to the ordinance, if a worker works on any waterworks, he is in breach of the law if he's not a licensed plumber. We don't want to hold him criminally liable. We need to spend a lot of time on amending the ordinance. The second batch of the amendments will come. We believe this amendment is simpler, and we do it first. And then in the next batch of amendments, we will deal with that I don't want to wait. We do not stop. Will the next batch be brought before us before the end of the year? Now, our position is that early next year there will be a proposal to consult. Well, that's similar. Now, consulting the trade is the issue, and I don't know how much time is needed. There are contractors, there are suppliers, there are developers, there are professionals, building services engineers, APs. There are many parties involved in the second batch of amendments. Those issues are more complicated than this one. The original proposal was to have our amendments at the beginning of next year. We will consult members at the panel, and then we will have a bills committee. We have to do it step by step. We have our proposal at the beginning of next year. Well, we'll wait for you then. Ms. Lina Wong, your second round. Now, according to Mr. Mack's proposal, they will deal with the suppliers, the contractors later. If we accept this two-step approach, we still have to deal with the supervisors. There are supervisors mentioned in the bill, and if the supervisors give wrong instructions, they will be held responsible. So there is a need to define supervisors in the bill. My idea is similar to, or nearer to that of Dr. Yu's. You need to define supervisors, and you need to have a registration system for supervisors. And the supervision they give will have to be closely related to water safety. Now, they may have inadequate understanding leading to another lead-in-water incident. In your paper, point number 7, they are allowed to get other people to work on site. These workers are not trained in terms of waterworks, and you rely on the supervisors. But if the supervisors do not have adequate knowledge, then how can you ensure water safety? They may only know how to connect the pipes, but they don't know the consequences of using what materials, and they may not know the standards, and they may not know the things are up to standard. They just do it, and that will be serious. There should be adequate training for the supervisors. The supervisors have to understand the law. Otherwise, there will be problems with the supervisors and the outcomes of the work done by the workers supervised under them. If they are held responsible, and if they are not provided with adequate training, then they better not do the supervision, and nobody is willing to do the supervision. As for the skilled workers and semi-skilled workers, they have the skills. As for the understanding of the law, they don't need to fully understand all the provisions. The licensed plumber has to understand the law fully.
The licensed plumber is required to undertake a course on the Waterworks ordinance before a license is granted. So it's the licensed plumbers who are required to learn about the Waterworks ordinance, whereas for supervisor, we're talking about supervisor of works. It's not about legal knowledge. So there's a difference as to whether we should include the definition of a supervisor in the bill. It's a drafting point. Maybe I can defer to my colleague to see whether it is necessary to include this definition in the bill. Ms. Lau? Well, maybe I can explain from the drafting perspective how we interpret the wording, interpretation or instruction or supervision. We have in fact added 13 capital B, which sets out the meaning of carrying out specified plumbing works under instruction and supervision. It doesn't expressly specify who can give instruction or supervision. In fact, the same expression has appeared in different provisions. For example, for the newly added 15 about designated person, it also refers to a person who carries out specified plumbing works under the instruction and supervision of a plumbing or a licensed plumber or a registered plumbing workers. As such, we do not find it necessary to specify the person in clause 13. And that's the reason why we have not spelled out exactly who can give instruction or supervision. And for section 14, bracket 4, we set out the persons whom may be committing an offense. For example, a person who gives instruction and supervision, or a person under whose instruction and supervision so and so. That means a person working under the instruction or supervision of another. But we have not spelled out who gives the instruction or supervision in these provisions. Members may have noted that there are certain workers who can take up plumbing works, licensed plumbers, and also skilled and semi-skilled workers. But we have not defined who can take up works of a minor nature, for example, and we have not therefore spelled out the persons concerned. And that's the tricky point of the bill, and that is why in 13 capital B we have not spelled out the persons who can give instruction or supervision. Dr. Wong, according to Mr. Mack, for skilled or semi-skilled workers, they will not be presumed to have knowledge of the Waterworks ordinance. Only the licensed plumber will be required to have this legal knowledge. But the point about this bill is that very rarely would a licensed plumber actually carrying out plumbing works in the site. We have 3,000 plus registered licensed plumbers in the trade, but according to the trade, only about 1,000 of them are active. Can 1,000 licensed plumber be sufficient to give supervision and instruction for all the works in Hong Kong? So for the actual operation, the thing is, in the absence of a licensed plumber, skilled or semi-skilled workers may give instruction or supervision to general workers who have not received relevant training at all. They may not be equipped with a legal knowledge. They may not know anything about the Waterworks regulation. They may not know the chemical reaction of lead and copper, which may cause contamination of the water source. They know nothing at all, and it's very unfair. And in such circumstances, I definitely would not take up a supervisory role because I have not undergone any training. I have no legal knowledge, and if raw materials are used, how should I take up a legal responsibility? Mr. Mack. As explained just now, the responsibility of licensed plumbers is higher than that of skilled or semi-skilled workers, because that's the requirement before a license is granted. They're required to take a test, and that's why we impose a higher requirement or stricter requirement on licensed plumbers. And we have a responsible licensed plumber concept in this bill. We may specify a responsible licensed plumber in each project, and the responsible licensed plumber will have the responsibility of ensuring the correct use of materials and compliance of the relevant laws by the workers employed to work at the site. The responsibility lies with this responsible licensed plumber. At this stage, at least. In the future, we'll also include the contractor, the professionals, but this will be dealt with at the next stage. This is our current proposed arrangement. That is to have a responsible licensed plumber in place to ensure the correct use of materials and compliance of the laws by the workers. As for other workers, we're talking about skilled or semi-skilled workers. We don't impose the same level of requirement, because for them to acquire a so-called license or registration from the CIC, we're talking about trade tests. For example, they may need to learn about soldering methods. So it's more of a skills training. That's the framework we put in place. I understand Mr. Mack's point, but the problem is, for skilled and semi-skilled workers, in this provision, they will be tasked to take up instruction and supervision, and there are two aspects. We can talk about the skills, and also in the course of supervision, whether they themselves have the knowledge of the possible impacts on water quality by the works they perform. And I want to know whether there is relevant training for skilled and semi-skilled workers in this regard. Otherwise, what kind of supervisory role are you talking about? I'd like to supplement 2 points. First, after the excess lead in water incident, we have discussed with the Construction Industry Council to see how we can include more elements in the training courses so as to provide more teaching materials to enrich workers' knowledge on the impact of water quality by the use of different materials. And we also have CPD courses. We're also discussing with the CIC about including these elements in the future training courses, so that be it skilled or non-skilled workers, their knowledge in this regard will be enhanced. And that's what we are going to do in the first stage. And as explained just now, the role of a licensed plumber is important, and when he applies to renew a license, we also impose the relevant training requirement. On this point, can the administration tell me about the CPD courses is it a voluntary or mandatory requirement? And will skilled and non-skilled, semi-skilled workers be also subject to the same training requirement? At present, it's not stipulated in the law that the license can be renewed only after CPD courses have been completed. Then that's exactly the loophole. Well, I think it also relates to criminal liability that we discussed just now. For skilled and semi-skilled worker to take up full responsibility of the whole water supply system, I don't think this is the objective of the law. But again, members have raised concerns on the drafting aspect of the bill, and perhaps Mr. Mack can carefully consider these suggestions. Mr. Peter Shield. Well, I think as many members mentioned, we do not have sufficient licensed plumbers. It's far fewer than 3,000, not even 2,000. And if you ask skilled or semi-skilled workers to take up this role, they have no legal knowledge. And I agree with Dr. Edward Yu that there should be another tier so that you can enhance the knowledge. The first point is that you do not have sufficient manpower. Second point, the legal advisor asked a question before. According to the Electricity Ordinance and the Lifts and Escalator Ordinance, prosecution will be initiated 6 months after discovery of offense. I have the text with me. After discovery of offense, the prosecution still has a time limit of 6 months, and on first conviction, it says level 6 fine and imprisonment of 1 year. And then following the subsequent convictions, imprisonment of 2 years and fine of $500,000. For the lift and escalator ordinance, on first conviction, $200,000 fine and imprisonment of 1 year. And for Waterworks ordinance, the tariff is a level 4 fine, $25,000. The level is different. For electricity and lift and escalator ordinance, well, let's say if a lift falls and if there is an accident, it results in fatality immediately. That's why the enforcement approach is different. And that explains why a level 4 fine is proposed in the Waterworks ordinance. Well, after the lead and water incident, there is widespread concern. But to peg the level of punishment in this bill to the electricity ordinance and the lift and escalator ordinance, once the works are completed, you will issue a certificate of compliance. And in the process, you also inspect the system. Once the installation is completed, they will need to get a certificate of compliance from your department, and the certificate certifies that your the system is okay, and you explain that it is done by random sampling, or random inspection. But in fact, you could have inspected every system. Let's say after it is the bill has been enacted, and if it's implemented, let's say if the if a section of the pipe is burst and it will need to undergo repair, and then perhaps the pipe will be replaced by a similar type of different brand, and then 8 or 10 years later, because there is no time limit, or even 20 years later, something goes wrong, and then you discover the problem. Why is it that this pipe belongs to a different brand? By then, the liability will be falling on whose shoulders?
Concerning the time limit on prosecution and the severity of the penalty have no direct relationship. Chairman, my question is for the department. Now, what is the relationship? If you are tough if the law is severe, therefore you need to enforce strongly. I just say that the time limit, according to my understanding, has no definite relationship with the severity of penalty. Apologies. There is nothing for you to apologize. Don't you want Mr. Meg to answer your question? Well, you answer my question. I have not answered your question. I just give my own opinion. I have not answered your question. That's not... You answer my question. No, I didn't. I asked Mr. Meg to answer your question. You don't need to agree with me. You don't need to agree with me. Why don't you allow me to speak? I give the floor to Mr. Meg to answer your question. Well, I've just given my view. Concerning the prosecution time limit, we have to consider the chance of occurrence of the offense and also the possibility of discovering the offense. It has nothing, no strong relationship with the severity of the penalty. I just want to explain to you, Mrs. Seal. As for Waterworks, the time for working on the waterworks and the time for testing the waterworks have a time span usually more than 6 months. Therefore, the existing law cannot be enforced. Even if we have discovered that they have used the wrong material, then they that has already expired. That has already expired the time limit. The question is, when did he use the wrong material? It's not the time for issuing the permit. Now you have finished your work, then we give the approval, then we issue the approval letter. But that's how much time do you need to give the approval? If you don't give the approval, they cannot proceed to the next step. Well, the approval is given on the completion of the works. It's not the approval we give at the start of works. After they've completed all plumbing works, and then we go to do the testing, and then we give the approval. But when we do the testing, that may be more than 6 months after the installation, and therefore we cannot start any prosecution at all. Therefore, we have to set the time limit on prosecution according to the discovery of the offense. In the past, it was adhered to the occurrence of the offense. Now we want to attach the time limit to the discovery of the offense. If we have discovered that they have used the wrong material and we believe we can prosecute, then we have to collect evidence, and we are given only 6 months to do that. The discovery of the offense, 6 months within the discovery of the offense. We don't ask for a long period of time. We don't ask for 10 years. We just ask for 6 months for collection of evidence. There has been no change to penalty. The penalty is the same, $25,000. I think you put the responsibility on people in the future generation. Now they have finished with the waterworks, and then they put on cement. Whether they've used the right material, you can send people to the site and look at material they use. And if there is no problem on the inspection, then there will be no problem in the future. Say in my hypothetical situation, if there's a burst pipe and people use another brand of water pipe, if it is discovered that the material is wrong, but that material is different from the original approved plan, then the onus of proof is on the prosecution. Say after 10 years, in your example, when I saw the material was different, we could not proceed to prosecution immediately. We have to collect evidence. You saw the wrong brand. How can you prosecute? Who will be prosecuted? Now that pipe has lead content. Who will you prosecute? It depends on the outcome of evidence collected. Well, I cannot give a general response. Somebody may have changed it in the middle. The original plumber may not need to be responsible for this. There may be no management. They just get anybody to fix the pipe. After 10 or 20 years, and then the flats have been sold, and then owners moved out. Even if there was no bursting of pipe, but after 10 years there was some problem. And then they claimed that somebody changed the pipe, and it was not his changing. How you collect evidence? That's purely on evidence. Now, after works have been finished, you send people to go to check, and then you take the responsibility. You can have all the certificates. You can check the certificates and check the materials. You can check the invoice. You can check the materials. If that's okay, then they cover the pipes with cement. In the future, after 20 years, there was a problem, and then you found that the pipes have been changed, then it's not the problem of the original plumber. Now you're just setting a trap for the licensed plumber, Mr. Mack. I thank Mr. Siu for his view. We have to balance the resources and the deterrent. If you don't have that approval, after this finished, the work has been finished, then the Waterworks comes to do the checking and then issues the approval letter. You just take samples. Now, if you complete, you get a complete check, that will be different. It will be costly. Now, you need to provide the cost implications. If people feel that they have to foot the bill, then so be it. It's so simple. Why don't you take the responsibility? You put the responsibility on not only the workers, not just the licensed plumbers. There aren't enough licensed plumbers. I think Mrs. Yu's point is very clear. After you issue the approval letter, then the licensed plumbers, the workers will be absolved of all the criminal liabilities. Mr. Mack, do you agree with that? As I said, we need to find a balance. According to Mr. Siu, then every time we do the checking, every step we have to do the checking, and that will be a very big demand on government resources. Our present proposal is a balance. It is a deterrent, according to our proposal. Whether they are plumbers or workers, if they have done their job, if they have done nothing wrong, they don't need to be worried. The onus is on the prosecution to collect, or on the department to collect evidence. We have yet to go into clause-by-clause study. In Section 18A, the standard of proof is beyond reasonable doubt. This is the beyond reasonable doubt requirement under Section 18A. The licensed plumber has to sign on the papers. All right, I think I have to give the floor to another member. Mr. Yu. Dr. Yu, your second round. Mr. Mack, let me clarify the issues. Now, this time, you want to amend the law to the extent that it reflects the current operation of the trade. That's your starting point. The improvements will have to wait for the next stage. Many members, including myself, want to amend the law so as to improve the current operation in the trade. My proposal is that you add a new post, say for example, plumber representative, and that is to improve the current situation. Now, under the buildings ordinance, that is AP.
有相關嘅權同
There is training, there is CPD. That's the whole construction industry. AP has criminal liability because he has the responsibility and he has the powers. Now, you're going too far. You hold ordinary workers responsible. Now, the duty and responsibility and powers are not balanced. The government may not agree to, the government may not be able to check everything when the approval letter is given. You need to rely on the professionals to check. Therefore, the professionals are given a very heavy responsibility. I think we should go back, we should tie this to the operation of the whole construction industry. Amending the law to reflect the current situation is not our objective because the current situation is not desirable. Therefore, we need to add something under licensed plumber. The licensed plumber represents the supervisor represents the licensed plumber to do the supervision, and therefore he is held responsible, and persons supervised by him will be absolved of any criminal liability. That's similar to the current construction industry situation. Mr. Mack. Yeah, thank you, Mr. Yiu, for your conclusion. As said by Mr. Yiu, we want to amend certain provisions which are not reasonable. Section 15, workers are doing plumbing works, but they are not licensed plumbers. They have already breached the law. That's unreasonable, and therefore we amend the law. We know that you want to improve the law. We understand this. We've heard the views of members. In our second phase, we will certainly consider your views. And as for Mr. Yu's, Professor Yu's proposal, we have a similar one. We want to have a BSE to play that role instead of adding a representative under the licensed plumber. We are thinking getting professionals, building service engineers, to take up certain responsibilities which have been taken by the licensed plumbers. Some responsibilities should be taken up by building services engineers or contractors. As I have said earlier, we are developing a proposal.
Well, then I think that you need to wait for the regulations first. Dr. Helena Wong, following Mr. Mack's rationale,
作為一個介入點去
well, if you take the approach of using fire service engineer to replace the role of licensed plumber and his responsibility, comparing to our suggestion, which is to rely on skilled workers in the plumbing trade by enhancing training and before letting the registered skilled workers take up a supervisory role. Why would you opt for your suggestion instead of ours? Because for the skilled workers in the plumbing trade, they are already equipped with the knowledge of the trade, and you're just providing training for them to further their skills and knowledge such that they can be promoted, so to speak, to take up a supervisory role. Why would you rely on an engineer outside the trade? Because the engineer may not be familiar with the plumbing trade. Thank you, Dr. Wong, for your comment. I may perhaps I didn't explain myself clearly. I'm not suggesting the building service engineer can replace this role, because about the CPD requirements and training requirements, I mean, the role will not be replaced. For large-scale projects, there is the presence of a building service engineer who is responsible for the alignment of pipes and the design, etc. And that means there will be independent supervision on top of the licensed plumber supervision. Well, does the supervisor in your bill include the building service engineer? So you only include the engineer in the next stage? And that is why we explained at the outset that we want to have a comprehensive proposal to consult the trade. It's rather complicated, covering quite a wide scope. So I hope that it will not be like Dr. Edward Yu said, that the bill will not be passed until the amended regulations have been passed. Because there is a problem with the existing ordinance that we wish to address immediately. Dr. Wong, setting aside the part about the building service engineer, because at the moment it's not in your bill, our concern is whether the supervisors have the sufficient level of knowledge of the skills and the law so as to perform his role as a supervisor of the plumbing works, so that first of all he will be following the law, and secondly he will be giving the right instructions. So we're talking about training, examination, licensing, so as to make sure that the right instruction and supervision be given. is the government refusing to do it, or are you just dragging your feet? Mr. Mack, let me clarify. Let's say without the instruction and supervision arrangement, how will this be done? The semi-skilled worker will be working on his own. The licensed plumber may instruct him to carry out waterworks in a certain flat or building, and that will be it. So why are we proposing to have someone carrying out instruction and supervision? We hope to implement this arrangement so that more workers will be equipped with their skills. Let's say the semi-skilled worker may be working in a certain unit, and then the semi-skilled worker can engage a general worker who is unlicensed to share the work. And if that unit is undertaken by that semi-skilled worker, then the level of work should reach certain standard. Otherwise, he should be responsible. But let's say if the semi-skilled worker engages a general worker, what we're requiring is for the semi-skilled worker to give sufficient instruction and to supervise the work of the general worker so as to complete the task together, so that he himself, who is capable of completing the task, can give instruction to somebody who is not licensed to share the work. A skilled worker may be responsible for the waterworks on the whole floor, but he can't finish the work by himself, and he needs to engage other workers, so he must give instructions to other workers. Chairman, the problem is, let's say if he engages a worker to help out in that unit, for the semi-skilled worker, it's all right because he's been trained, but other general workers may not be the same. Apart from doing the work himself, the semi-skilled worker will also need to coach other workers, but it may not be up to him. The other general workers without knowledge may be engaged not by himself, but by other contractors or subcontractors. These workers may have come from other sites, and these workers may not have the relevant knowledge, but then the worker giving instruction would be liable. We agree that clear guidelines should be given to the workers and persons giving instructions and supervision. As explained just now, in the coming months, we will discuss with the stakeholders concerned on the drafting of the guidelines. For example, what the worker should have done to meet the legal requirements. I understand that members are very concerned, and we note members' concerns. In the coming months, this is what we will do in terms of the guidelines for persons giving instructions or supervision. We'll make sure that there is sufficient communication so that everybody understands their respective roles and responsibilities. As to Dr. Wong's point on whether there should be relevant training for those giving instructions or supervision, we can discuss with the trade, and if necessary, we can also discuss with the CIC. It's an interactive process, and we keep an open mind. If the trade believes that this should be implemented, we can make arrangements. Well, I think we should allow the next member to speak. Dr. Wong raised some concerns, but this is the concerns shared by other members. but not everything can be dealt with in this bill. For example, about the code of practice or guidelines for the trade and training. Mr. Peter Shiu. Chairman, on 2 occasions the department told me that the provision will be 6 months after discovery of the offence, which is in line with the electricity ordinance and the lift and escalator ordinance. I don't quite agree, because for Waterworks ordinance, the tariff is a level 4 fine, $25,000, and no imprisonment term, whereas for the electricity ordinance and the lift and escalator ordinance, there is an imprisonment term of 1 year. Why are they much stricter? And despite that, you take the same enforcement approach. Because this is about 6 months after discovery of the offence. Originally, for the Waterworks ordinance, it's 6 months after the occurrence of the offence, whereas for the other 2 pieces of legislation is 6 months after discovery of offence. For the Waterworks ordinance, at present there is no imprisonment term. Even in the future, there is no imprisonment term. It's just a level 4 fine. So why is the enforcement approach the same? At present, we cannot enforce the law, and that's the point. Usually, by the time we are able to enforce the law, it will be beyond 6 months after occurrence of the incident. Well, how much time would it take for you to issue a certificate of compliance? Now, we're not talking about the issuance of a certificate, but rather at the time the offence is committed, that is, when the installation is taking place. Right. But they will be required to submit an application for works to be carried out. How much time does it take to process the application? For a building, it may take 2 years, 3 years, and sometimes it may be shorter. But in general, for a large-scale project, we're talking about years of completion. So by the time we inspect the final product, we won't be able to initiate prosecution because it's out of time, just like the lead and water incident. That is why we need to revise it to discovery of offence. I understand the plight of the department, but how about if we change it to something like this? Let's say at the time when you issue the certificate of compliance, regardless of how many years it has taken to complete the construction, when you discover something wrong at the time when you issue the certificate of compliance, you can then initiate the prosecution. I think the question is clear. Mr. Mack, I understand Mr. Shiu's comment, but we still need to spend some time to consider the issue and the implication on our enforcement. Well, I think that it has to do with manpower. You can increase manpower, and you can also inspect comprehensively, because by issuing the certificate, you suggest that it is in compliance. But under the new legislation, you're suggesting that 20 years down the road, you could say that you didn't inspect clearly because it was only done by random inspection. But in fact, you could advance your effort. You can just increase manpower to inspect the system, because that's the case for every new legislation introduced. There will be additional costs, and it will be borne by the public. Why is it that you need to you delay the problem to much later? Because if you do random inspection, inevitably there will be problems. You're just delaying the problem to later. Your point is clear, Dr. Edward Yu. I have one final question. Just now, I suggested having licensed plumber representatives in the bill. to allay the concerns raised by members.
行業
And my proposal is in line with the Buildings Ordinance framework, and that is also not in conflict with your BSE's proposal. Now you will have an AP for building services. Just like building works, you have AP. In building services, you have also an AP. In construction industry, you have contractor. On this side, you have the licensed plumbers. And in construction, you have signatory. And on plumbing, you have the supervisor or plumber's representative. I don't know whether you're going to amend the law, or I'm going to amend it. If you want to add a representative of the plumbers, then you have to specify the qualification requirements, his duties and responsibilities. We have not gone through any consultation, and therefore it will be difficult for us to add this. I suggest we leave it to the next stage. Of course, Dr. Yeo is entitled to move an ECSA. Dr. Lina Wong. Chairman, I have another follow-up question concerning CPD. The licensed plumbers, in renewing their licenses, can participate in CPD on a voluntary basis. How many of them do this? And also, why not compulsory? Well, that is not an arrangement instated a long time ago. It has just been introduced recently. Now we introduced the voluntary arrangement so that the trade will update their knowledge, and we would like to see whether that goes well or not. We don't want to legislate on everything. After the lead in water incidents, the trade is of the view that it should upgrade itself, and therefore we have the CPD arrangement. We talk to the representatives of the trade unions and other parties, and they are rather positive towards this. And if participation is enthusiastic, then we may not need any legislation. If we think it is worth doing, we do not rule out the possibility that we will go down the legislative route. Chairman, can we ask the administration to provide the numbers to us? Now, 2 years have elapsed since the lead in water incident. How many licensed plumbers have renewed their licenses, and how many have received CPD? Well, I can provide the numbers. As I said, it was introduced just a year or so. We can provide the numbers. In CPD, is there anything related to potable water safety and also related laws? Well, I can provide the information afterwards concerning the contents of the CPD. The answer is basically the affirmative, but I can provide the details afterwards. If education and administrative arrangement can be done, then you can proceed with legislation very easily. In terms of water safety or potable water safety, you may require the plumber to receive CPD upon the renewal of the license. That can include the various safety standards in respect of materials. If they have studied the course, then they cannot say that they do not understand. And therefore, in supervising the workers, there will be no departure from the requirement of the law. So if CPD is mandatory, then there will be no excuse. I think Ms. Wong's view is very clear. As I've said, there are certain things that can be done by the bill. There are things outside the scope of the bill, although they are related. I think Mr. Mack is very clear about it and is also working in those areas. Mrs. Seo, let me go back to the issue on the time limit.
我解釋好清楚啦，就講話哦，因為佢哋開工俾個開工紙同埋。
Now concerning the approval of plan to the issue of compliance letter, it may take 2 to 3 years. I understand that, and I agree with you. But can you extend it to ad infinitum? If you check the laws, they have a time limit of, say, 6 years. I think you should not lengthen the prosecution time limit to ad infinitum. I think you should at most extend it to 6 years. I think the responsibility is on the department. When you issue the letter of compliance, you should have checked the pipes comprehensively. You can see with your bare eyes. You can see whether they use the materials required. You can see the brands printed on the pipes. You can see the invoices. You can check everything. Now, give us your cost if you check everything. Now, if you check everything and then you issue the letter of compliance, and people can feel assured. And if something untoward happened, then somebody has done something wrong in the middle, not at the beginning. Well, it's very likely that I move CSAs, and I also support Dr. Yu's CSAs. Well, we have 6 minutes before the end of this meeting, and it's impossible for us to go into clause-by-clause study of the bill. And I believe Mr. Mack and his colleagues understand that there is a big concern in respect of the quality of Waterworks, and there are also concerns about the wording in the bill. I believe during the summer recess, the department will continue to talk to the stakeholders of the Waterworks trade, and the department will also look into the codes, guidelines, and practices, and we will only be able to study the bill clause by clause. Ms. Wong may not have time to ask further questions. I want to ask Mr. Mack. I think that's important. What is your timetable? Well, what I have said is realistic. We can only continue clause-by-clause study of the bill after the summer recess. Well, I understand this, Mr. Chairman. We, of course, very much hope that the amendment bill can be passed as soon as possible. As I've said, we don't want to cause the workers to worry about what they are already doing now because of the provisions in the existing ordinance. We will continue to talk to the trade, in particular with regard to explaining instruction and supervision and how we can deal with it in a better way, whether it is in the text or in respect of the guidelines. As for the timetable, we need to wait for you to come back after summer to conduct the clause-by-clause study of the bill, and we hope that can be resumed after you come back from your summer recess. We still have some time left, a little bit of time left. So, Ms. Wong, Paragraph 8, in respect of Section 15(2), works of minor nature. I ask why the administration does not provide a definition. I cannot accept the reply by the administration, since the reply is that there will be circulars issued in defining works of a minor nature. I hope you give me the list and also the principles for including those works in the list. I still believe that we should regulate the water authority in respect of its understanding towards the term works of a minor nature. In fact, the subsidiary legislation will deal with this as well. The pipes and accessories should not affect the efficiency and quality of water supply. Should we understand it this way? This works of a minor nature refers to anything that will affect water supply safety and water supply efficiency. The details should be will be prescribed in the guidelines, but it is also not appropriate not to regulate what is meant by works of a minor nature. If you will answer me after you come back, after we come back from summer recess, and if you don't make any amendment, I will move an amendment. Mr. Mack, do you put this in? I believe you've put that in the website. Yes, indeed, and we'll provide the answer in writing afterwards. When will be our next meeting? Well, we are unable to fix the date of our next meeting. We have to wait for the timetable of next session. Will it be in September, October? Probably it's October. We want it ASAP, of course. All right. Well, we have to wait for the resumption of the council, and that will be in October. And once we have a time slot, we'll start our work. Thank you. Meeting adjourned.